like to welcome everybody. Good afternoon, good evening for some of that, for you, and good morning for Patrick there overseas. So first of all, I would like to say that for those who will need the interpretation, down in your Zoom application, you'll find the interpretation button. And in order to listen in Georgian language, you have to choose English, German language, and you will then hear all the interview in Georgian. Okay, let us start now, and our participants will join same time. It is my pleasure to welcome you on behalf of Georgian International Arbitration Centers, and it is my great pleasure to open and make this short introduction. As you know, every year Georgian International Arbitration Center is organizing the arbitration days, which is the major event in this region. But unfortunately, due to the well-known circumstances that is due to the pandemic, we decided to do some of the online events through this period of time. And the next one we have today, this is in format of interview, and it is our great pleasure and privilege to have Professor Julian Lew QC. And it is really great opportunity for our local practitioners and all our other GIAC interested people. Same time, we have the Patrick W. Pearsall, who is I have to mention that he's a very good friend of Georgia and also our supporter, and the ones we decided to organize such event, he very enthusiastically accepted on this, and now we have him as an interviewer. And a bit I will speak and present him. He's a partner at law firm Allen and Overy. He's a member of the teams, the firm's international arbitration and public international law practice based in Washington, D.C. Prior to joining the firm, he was partner and general block. Before that, he had the respected career in U.S. government, in State Department, where he was serving as a chief of international investment arbitration. He worked on the matters related to global commerce, including the investor-state and state-to-state dispute. He is also a professor in Georgetown University in a law center, and he is also the member of some international arbitration centers. I have to also mention that he is very, very interesting and a prolific speaker, and who those has been in Georgian arbitration days last year, you might remember his very, very brilliant speech, and really it is honor to have Patrick here as an interviewer. Now I will not continue anymore with that, and I will let you to listen this interview, and Patrick will continue with that and present Professor. Thank you for your attention.
Thanks, Becca. The honor is mine. I wish I was back in Tbilisi with you all. And thank you, everyone, for spending your afternoon with us. Garmarjoba to all of my friends in Georgia. I miss you very much. But we have a very exciting program for you today. I'm thrilled that I get a chance to speak with Professor Lew, who's been a great hero of mine for a while and is going to probably stun you all with his enlightening comments. But let me first, by way of just introducing him, and then we've got some topics, and hopefully we'll have time throughout and at the end for questions. So stand by for that. Professor Lew has been involved in international arbitration for more than 40 years as an academic, as counsel, and as an esteemed arbitrator. He was born in Johannesburg, South Africa, and moved to England at the age of 13. He obtained his law degree from the University of London in the late 1969, I believe. He decided to become a barrister primarily because his parents told him that he needed to be authorized to appear to be called a lawyer. I don't know, Professor, tell me if I'm getting any of this wrong. During his time as a pupil, his first arbitration case was working alongside who would later become Lord Mance and Lord Gough, both of whom who would sit on the Supreme Court. He got his PhD from Leuven in Belgium, specializing in international commercial arbitration. And since then, he has been one of the kind of pillars of the international arbitration community, both in private practice and as an academic. On the private practice side, he worked at several law firms, including Coudert Brothers and Herbert Smith. He was qualified in England and Wales and New York. He was famously the head of the international arbitration practice, the great international arbitration practice at Herbert Smith, until becoming a full-time arbitrator in 2005. I hasten to add that in 2002, Professor Lew was given the great honor, one of only a few solicitors to be awarded Queen's Counsel. On the academic side, Professor Lew started teaching in Belgium and then moved to Queen Mary University in London, where he founded the School of International Arbitration in 1985. And of course, we all know Queen Mary is perhaps the most respected academic institution for international arbitration today. He continues as a professor of international arbitration and head of the School of International Arbitration. And in addition to teaching, if that wasn't enough, to have a storied career and being a very well-respected academic with a number of books and articles, he's now a full-time arbitrator at 20 Essex Chambers, specializing in both commercial arbitration and investment arbitration. And he's taken on, he sat on a number of very influential tribunals, and he's taken a number of very important institutional roles. He's been a member of the ICC International Court of Arbitration, the SAIC Court of Arbitration, the Hong Kong International Arbitration Center's Advisory Council, and numerous others. So I will stop there. I'm sure I could take the entire 40 minutes in going through Professor Lew's amazing CV. But I thought, Professor, just to start us off, if you wouldn't mind kind of indulging us just in your early career a little bit, and maybe, I don't know, start with your first appointment as an arbitrator and kind of how you moved from counsel to arbitrator.
I will. Thank you, Patrick. And let me say what a pleasure it is to be here. I hope one of these days I'll get an opportunity also to visit Georgia. And I've noticed in the audience today that there are a couple of my past students, and I'm delighted to see them. And if I haven't recognized anybody, I apologize. And some individuals who I've had the pleasure of having as counsel or co-counsel in arbitrations, which I've been involved. I came into arbitration in some ways by unexpectedly. And once I got into the subject, it was one of those where I felt comfortable. It was the international side there that I enjoyed particularly. And from publications, I don't really know how I got my first appointment, but I do recall it was an ICC case. I think it was in the early to mid 1980s. It was a small case, and it arose out of a pharmaceutical dispute, and it was parties from Portugal and from France. And my vague recollection was the big question was, what law governs? And of course, at that stage, I had recently published a fair amount on that, and including a book. And maybe that's why I was appointed. I don't know. One never really knows exactly why one's appointed in a case. One hopes it's for good reasons.
Yeah, well, what law governs is a perennial question. It's kind of the first question that we're all asked when we look at a case. When I started in law school, I didn't really know what international arbitration was. I just knew I wanted to do something international and probably contentious. I wanted to be a litigator. Is that kind of how you found your way toward international arbitration, or did you?
No, no. I think that as a very naive teenager, I used to watch television, and there was a program called Perry Mason. It was a very famous TV program of a criminal lawyer who always got his client found not guilty somehow or other. And it was my weekly watch on the TV. And so I decided I was going to be a criminal lawyer. Then I went to law school. And from there, the subject that really caught my imagination was private international law. I enjoyed public international law, didn't quite do comparative law directly, but it was private international law that I felt most comfortable with and understood, and that took me in that direction. The reason for that, I don't know, but it could be my own background, born in one country, from parents born in two different countries. My whole background was mixed, and therefore I knew the necessity of mixing of people who are automatically a mix of different backgrounds, different cultures. And that is the essence of international arbitration, because it's all immediately on point one, parties from different places. You don't have to go any further. Different places, maybe legal, maybe factual, maybe numerous places, increasingly with multinationals. So that was where I came in and felt comfortable in that area straight away.
And I think it's an interesting point you make, because it's also one of the few practices in the world where you can, as a practitioner, sit as arbitrator, but then also, at least in commercial cases, serve as counsel. I wonder if you had, difficulty making that transition, or if you really kind of wanted those Perry Mason moments as counsel and you missed them as arbitrator.
Well, I certainly missed a certain amount. What I missed from counsel's work was the adrenaline, because when you are working on a case and you have a case tomorrow morning, you're waking up in the middle of the night. Have I got my arguments right? Have I prepared my examination of witness? Am I right about that document on which I want to make a submission? One has completely different adrenaline as an arbitrator. But so I don't think that was, what I was lucky is that I was able to take on a small number of cases while I was still a lawyer in law firms. And that's something I would like to say to many people. I think it is, there are not enough lawyers in law firms who are doing arbitration work who actually sit on the other side of the table. Because I believe that if you do sit on the other side of the table, lawyers would react differently in the way sometimes they present an argument. Because one needs to remember that counsel are there representing a client, trying to put their client's case as best and as accurately as they can. Arbitrators are there to hear both sides, understand both sides, and decide on the balance of the law, on the balance of the facts, and on the evidence they've seen, where they believe the correct answer lies. And it's a different presentation.
And do you think, so Emmanuel Gaillard, also a great friend of the Georgian International Arbitration Center, has written about the kind of increasing specialization of the practitioner's role in arbitration. And do you think that, a lot of more junior folks in their mid-career are giving up counsel work to sit full-time as arbitrator and haven't done enough counsel work really to have that back and forth on both sides of the table experience? Do you think that that's an existential threat to kind of the healthy development of international arbitration? I mean, there's a real concern about double hatting, but do you think that it's, at least in commercial arbitration, that this is something that we should embrace, the double-sided table aspects?
One of the most interesting questions is how often I'm asked, and have been asked over the years by students, how do I become an international arbitrator? I don't think there's an easy answer to that.
Yeah.
But I do understand that there are people who would like to be a judge. And in the civil law jurisdictions, judges start normally at, they're trained to be judges. And that doesn't make them bad judges at all. They're just as good as any other judges. They get their experience from somewhere else. And what an arbitrator needs is experience and understanding, and to help the opportunity to develop their own approaches to different situations. So I don't think it's necessarily a bad thing for people to come in to be doing arbitration at an earlier age. And you see now the number of people who are going full time. Maybe there's something else, that in the old days people retired in their 60s or in their 70s. Now people are going on very much longer. And so with law firms, which sometimes push out older partners, there are many people who still have all their faculties available, and they've still got their energies, and they're happy to continue. And now younger people are saying, well, actually, I'm not sure I want the pressure of a law firm. And I just think, and we've also seen it somewhere else, there are other areas of full-time arbitrators. The shipping industry, and not an area that I do very much work in, but that has a lot of commercial arbitrators. The commodities, which are normally specialists in particular areas of commodities, certain amount of construction people, particularly the engineers and the other individuals who are experts, who start doing arbitration as well as their expert work. And I think that brings another dimension to the practice. So I don't think it's necessarily a bad thing if younger people come in. So
Yeah,
when they feel confident enough that they feel they've got the relevant experience.
And of course, there's the skills that you learn through practice, and obviously being an arbitrator is a practice, and there's a set of skills, case management, your ability to focus on the issues that are actually at stake, your probably your assessment of credibility and other things. You learn that with experience and over time. And I think that being a specialized arbitrator has some benefits. Query whether from a commercial arbitration perspective versus an international investment arbitration perspective, there are differences there. Do you think that there are differences there, like common law versus civil law differences that we all are aware of? Do you think that there's a difference?
Those are very different issues. I think that there are differences in the commercial and the investment. The investment is more of a concrete development, and whether it's a good thing or not, I don't know, but there are concrete questions as to the development of investment arbitration law, because who are the source of these rules? Yes, there is a case and the decision might be clear and might be obvious, but that doesn't mean it should always be followed. And that is an evolving area of investment arbitration, whereas commercial law arbitration is a one-off. And it's only in the last few years that we've begun to see more and more commercial arbitrations becoming public. And I'll say something about that in a minute on arbitration generally. So I think that they are very much the same. But when you start looking at into other areas, I think that the skills are very much the same. It's that ability to listen, to hear, and understand, and also very important, not to be shy of asking difficult questions. The questions, sometimes you want to ask the questions the counsel don't want you to ask. And there are times when you want to ask a question, but you don't. So there are those type of issues that do come about, and I think they're very, very important.
Yeah, it's an interesting point you make about the character of investment arbitration being more public than the character of commercial arbitration, which obviously historically has not been. I also wonder what the fact that, I mean, if you just saw the news 2 weeks ago at the IBA, they're publishing a database that's going to be hosted on Mundi about that'll host all the commercial arbitration awards that are known. Obviously, the ICC is starting to be more transparent in publishing précis or abstracts of cases that have been decided. Do you think that that's going to obviously it'll change the character of how counsel approach things, right? It'll make the pleadings more robust. It will likely allow third-party funders to do all sorts of statistical analyses. But do you think it'll change the character of how arbitrators approach those cases as well, when they know that they're writing for posterity?
Absolutely, absolutely. And let me just express a conflict of my own. In the 1970s, early 1970s, I spent some time with the ICC with their permission, and I reviewed their awards, and I was the first person to publish extracts of awards. And it was quite controversial then. Now, of course, we've gone to the other extremes. But there's one thing you missed. You said third-party funders, you said counsel will be able to argue their case. Whose arbitration is it?
Mm.
Who owns this concept? It's not the IBA with all the good works they do and some of the things they brought out. It's not ICA and all the great stuff they do. And it's not the law firms who are building up expertise in the international arbitration. It's the parties. It's the general counsel in big corporations and the general contract managers in smaller companies. They are the ones who've decided, I won't come to your court, you won't come to my court. We don't want to go to a national court. We'd like to go to arbitration. Why? Now, for many, many years, we were told they wanted it to be confidential. Whether they wanted absolute confidentiality or not, we don't know. Because you can have absolute confidentiality by putting it into the agreement. But lawyers don't want that, because now lawyers are promoting themselves and they want to be able to say, oh, I was involved in this big arbitration and in that. And I don't mean any individual lawyers, I mean law firms. And understandably, and of course the directories encourage it.
Right.
Because they're trying to promote the directories as well. So that's what's leading this change. Is it for the better of arbitration? I'm not sure, because I think one thing is likely. We are now seeing more and more cases going to the courts. In the early days, very few cases went to court. Arbitrators made a decision. They got it right, as they most of the time did. Sometimes they got it wrong. Parties might not have been very happy. Very rare did anything end up in a court. Nowadays, we're seeing more and more cases going to a court. And I don't know what the statistics are of how many succeed. And the reason is they're now knowing more and more information about cases. Is that better? Whose information is it? I would suggest to you it belongs to the two parties, or if there's more, 3 parties, 4 parties, but it doesn't belong to the institution. You know, so the ICC make you opt out of publication.
Yeah, I think it's certainly it's a good point. I mean, I think pushing back on it, or at least what Judge Kirby, I think, said in the IBA arbitration day 2 years ago or something in Montreal, seems like a lifetime ago with the pandemic. I think the concern is, without awards being published, the kind of the development of contractual law. I mean, this is a very common law perspective, I guess, but the development of contractual law is snuffed out because it's left in the shadows of confidential arbitrations, where the real interesting decisions on force majeure and all the other things are being decided because it's been removed from the court. And that's a problem for the development of the law. And as, you know, stewards of the law, it's a very important thing that we allow that to develop in the full light. You think that that has weight?
Well, you may know that in this country we had some criticism of a former Lord Chief Justice a few years ago when he said we are losing out in the English courts.
Right.
The courts are there, they're set up by the state, state by state. And we should also recognize one other thing. In most countries, the courts are very high standard. Nobody is criticizing the courts. But the question is whether a national court is something where parties are happy to go and have their disputes resolved. If we want to have international courts, and we see the move in the investment arbitration world currently of setting up these international courts, that's fine. Set them up and let parties choose. They're happy to go there with multinational judges appointed. But if you don't have that, then the real issue is why are people from outside trying to turn the commercial into a court system? Is that what party wants? You're right. We'd all like to know more about how different ways of applying force majeure and hardship clauses and the various other concepts we have to look at. But if that's the case, is it appropriate? I used the expression in a lecture I gave a year or so ago in America about voyeurs. Are we being voyeurs by looking into somebody else's case?
Yeah, well, it's an excellent point. What about certainty? What about the question? And we can move from this topic, but it's fascinating because I mean the other aspect of at least the common law approach, and you are one of the few kind of practitioners that have advanced degrees in both common law and civil law jurisdictions. So the common law version of this is that over time, if you can see how multiple tribunals have ruled on a clause that is very similar in your contract, right? I mean, sales contracts are not, necessarily exotic. They all very much look the same. If you can see how tribunals have ruled on them over time, that provides commercial certainty, which is also something that the law should strive for.
Well, if you look at the arguments that I made on this particular subject back in the late 70s and the early 80s, I said exactly what you've just said. But I'm not, so I don't deny.
I may have done.
I don't deny that this has there's a lot of benefit of being able to see not only how arbitrators of different kinds and different tribunals are reacting, but also to see whether we develop international commercial law. Now, there's a whole question. Does the lex mercatoria exist or not? We're not going to go into that today. But there is an argument in favor of internationally commercial regulations and how they should be developed and who should develop them. There's an argument for another time. But so that is an advantage. The question that I ask is whether one is entitled to collect that information from other people without their agreement. And I wonder how many of major corporations and governments that are involved. Governments, of course, are subject in some countries, at least, to a certain amount of scrutiny. They don't always like it, but there's nothing you can do about that. But with commercial organizations, the question is, there are recent issues they don't want to have public, and is it right to force them to have to face these things publicly?
Yeah, well, I mean, it's true. Let's talk about public arbitrations just for a second, and then we can move from the I guess the questions about transparency. I mean, when you're sitting in an investment arbitration case, do you think that yes, the law is a little bit is different. It's a more public setting. Do you feel a different responsibility? Do you feel a different weight on you as an arbitrator when you are sitting in judgment of a regulatory act of a state, or is it a dispassionate kind of and maybe this is not a good binary to construct, but is it a dispassionate, this is just two parties with a dispute?
At the end of the day, I think it is two parties with the dispute. Obviously, you have to take into account all of those factors, as one does when you're dealing with a commercial matter.
Yeah.
But at the end of the day, there are the issues that are already in case. In the public international cases, there are issues concerning when governments have introduced legislation, whether the legislation was correct or not. That has national legal implications, may have international law implications as well. And one has to take those into account. And of course, there will then be the arguments on the two parties.
And do you see the bar, the people who are appearing before you? Do you see a difference in the quality of preparation of counsel with regard to investment arbitration versus commercial arbitration?
No, well, look, I can't say that. I would say this generally. I think we are very privileged now to have a lot of wonderful lawyers, very thoroughly prepared. I have one criticism, which I'll come to in a minute. Very thoroughly prepared. And who present their cases extremely well. But the one criticism, the major criticism I have of a lot of lawyers is that they do not understand, many of them do not understand international law, private international law, comparative law. Because when you've got a tribunal comprising 3 arbitrators from 3 different jurisdictions, under whichever rules you want to pull out, you will in many cases have counsel from 2 different sides who will have members of their team from several jurisdictions. And that's helpful, because once you are able to think as a lawyer from one jurisdiction to another jurisdiction, that immediately makes it easier for you to understand the arguments that are being made from lawyers who come from other jurisdictions. And of course, we love talking about the common law and the civil law.
Right.
But there's a lot of other jurisdictions as well as that. And big differences between some common law jurisdictions and some civil law jurisdictions. And I think that in addition to the public international and private international and comparative law, there's one other factor which greatly helps, and that's an understanding of languages. Because just the way you say hello to somebody in different languages changes your mindset. And you need that to understand way somebody does business or did business, and you need to understand that in the context of the way somebody may react to a particular situation. Again, doesn't mean one's wrong and one's right. It's different.
Yeah, well, I couldn't agree more. And you very modestly omitted that you have been awarded the best prepared international arbitrator in the world by GAR, I think in 2015, which is quite an accolade. But you know, your suggestion that we should be more prepared as counsel, I think, is a good one. How do you think that from a kind of case management perspective, how can counsel be more helpful in ensuring efficiencies, right? I mean, we've heard a lot of criticism of international arbitration generally, that it is becoming more expensive. Americans like myself have been accused of introducing discovery and other kind of odious aspects of international arbitration that have moved us from this kind of halcyon view of a very efficient process that I don't think really ever existed. But how do you approach case management? How can we be more helpful to arbitrators as counsel?
Well, I'm not sure whether you're asking me how could counsel help me or how I can help counsel, because I think both can help.
Yeah.
The point is we have to get over a certain mindset. In 20 years ago at the Millennium Conference, which was organized in London, I put up an idea and I said, have we got to the stage as lawyers, as arbitrators, where we should allow in the Western world the idea that an arbitrator can act as both a mediator and as an arbitrator, turn over, close the door, walk out the room, act as a mediator, come back in if they don't settle. And it was shouted down. Nobody was interested in that idea. I think we haven't got there yet, although that is the case in certain parts of Asia. So whether arbitrators should be able to sit down with parties and say to parties, and some Swiss arbitrators do this, indicate that they're not persuaded by a particular argument. And if you know that early on in a case, it enables the party and with their lawyers to maybe review the position they're taking. So I think in some ways, and I had a case some years ago with an arbitrator, it was a pharmaceutical case, and he understood the issues, and one by one he picked off the issues and said, well, if the claimant loses this point, then we don't go any further. And then we got to another point. And so because these were all big points and very scientific, he was able to pick that up, and counsel was happy. I was one of the counsel. We were happy to allow him to do so. So I think it means there has to be a trust and a willingness to work together. You frequently see cases which are they're not going anywhere, and one would like to sit down with counsel and say, "Can I help? I don't want to get involved in your arguments, But if you've got a dispute and you have to resolve it, and they might be just fighting about something procedurally between them, or they can't agree. And if they can't agree, first of all, it may be the one is wrong and the other isn't wrong, or it might be there's a third option, but neither is prepared to make a concession.
Yeah, I think
and it's easier that they can walk away and say, oh, the arbitrator made us do that. So, but that's something which I think should come at some stage.
Yeah, I
and
think
that's helping how arbitrators might be able to help parties. How could counsel help me?
Yeah. Well, firstly, I would say that if I was appearing before you and you kind of broke character and said, "Hey, can I help counsel?" I would both be horrified, but also thrilled, because, you know, horrified from the perspective of, well, I thought I was kind of managing this and helping, but thrilled in that, you know, at the end of the day, you can't lose sight of that arbitration is for the parties, and it's a peaceful settlement of dispute between parties that they kind of choose for themselves, and obviously the parties should be front of mind. So thrilled and horrified at the same time. But yeah, how can
I won't take you to war stories, because I've had war stories myself from days when I was counsel. But the one thing which counsel don't want to lose is control of their case.
For sure.
They've got a strategy. They want to put their strategy. That's why I'm going to come back to how can counsel help me. They've got their strategy. They've worked it out. They've agreed it with their client. They know their strengths, and hopefully they also know the weakness that they get, and they're trying to bring that to the tribunal. But sometimes they can overcomplicate something. And sometimes they can not see a situation where they could make it easier for the tribunal. And are those situations where counsel should sit down perhaps and say, now, what does this arbitrator need to be able to help me? How can I induce this arbitrator to come to the solution I want? Remember, in most cases, you've got good counsel on both sides, and they're both arguing a very good case. Of course, each one is saying to the tribunal that the other case isn't very good. But if you can find a way to help the tribunal, that greatly assists.
Yeah, and do you, well, I mean, absolutely. I think one of the things that counsel, and not to kind of play the role of counsel here, but I think one of the things that counsel is concerned about in bringing evidence to a tribunal is the kind of back end of an enforceable award or in an investment arbitration, the annulment panel. And, you know, Toby Landau and even the late Johnny Veeder have both written on the need to put reasons into your opinion, but also the kind of extraordinary lengths now that tribunals need to go to kind of fill out their awards. So, for example, if I need to say that, you know, X company was founded and consolidated in the laws of X, should I need to put the deed of incorporation as Exhibit 1 and as Exhibit 2 of my pleading, or is it sufficient for an arbitrator to just accept that because I'm an officer of the court and I've made this assertion? Do you have a view on kind of, you know, the proliferation of evidence? Why do we need 400-page arbitral awards in an investment arbitration case recounting every word that every party has said?
Because that's why it is developed. That's what has developed over the last 20 odd years. Who do we want to blame? Do we want to blame the institutions? Do we want to blame the lawyers? Do we want to blame the arbitrators? Each one wants to pass the buck to somebody else. But commercial arbitration is easier to blame, to ask the parties, not their counsel, the parties to take responsibility. And maybe there's a certain amount of that which should also exist in the investment cases.
Wow.
It's a very difficult analysis.
To misquote Shakespeare, first blame all the lawyers. I think that's the way that we should do it. So let's shift to kind of future gazing, and we have about 15 or 20 minutes left, and then I'm hopeful to get questions in that time also from the audience. So please do put your questions in the Q&A chat function. So here we are virtually. I'm curious whether you think that this is going to persist as a format for us going forward. And similarly, if you were still, and this is a question that I wanted to ask for you personally, I hope everyone else is interested. If you were still running the Herbert Smith's practice, how would you be kind of positioning that firm or the practice to be responsive to the next 5 to 10 years of international arbitration?
I have no idea. The law firm too. I think what do you need to provide a great service? The first thing that lawyers need is an ability to make their clients comfortable, to feel this is a lawyer who can do the job for me. The second thing is that one has to do is to actually then have the skills to do that, to be able to, whatever the case that is brought to the firm, to be able to provide that skill. And law firms should invest in hiring young people. Make sure you bring in that generation. I should tell you, I've learned, I'm working now largely electronically. But when I see the young people do it, when I work with younger people, boy, are they quick. Let's get up exhibit 25. And by the time I go into the system and I get exhibit 25, they're already sitting there waiting for me. Now, and I'm pretty good on the electronics. But what I'm really saying is that it's the younger generation. In my days at Herbert Smith, one of the things I did in the early years, I always made sure we had 2 or 3. We had foreign officers, not as many as the Whiten cases and the Allen and Overys, but we had foreign officers. But I always had in our arbitration group 1 or 2 or 3 non-English lawyers. They brought another dimension. They thought, God, we may reach the same conclusion, but we came from a different way. So I think it's building up those skills what the lawyers will have to do. And I think they'll also have to teach many of their young lawyers that the idea of jumping on an aeroplane every second week to go off to a hearing in some lovely city, wherever it is around the world, is going to reduce enormously. Because what we have learned now is it is possible to have hearings, certainly preliminary hearings, certainly hearings for specific issues. Those can be done in 1 day or 2 days and 3 days on a virtual platform like we are today. I think that can work extremely well. There are times when lawyers and arbitrators will feel they need to be together, and those we will see that coming through. But I guess we've got wonderful systems with I'm not going to mention names, but different systems that already exist for these platforms. Each of these platform providers are probably already working on the next generation or even the generation after, more efficient, more reliable, better sound, etc. And I guess there's some manufacturers out there who aren't in the business yet, but will come onto it. So 2 years from now, we're going to have fantastic systems. Hotels will lose out. Restaurants may lose out. We'll still be working just as hard. And it won't be necessary for people to fly all over the world. They'll have to do it to an extent, but far less.
Yeah, well, I mean, we'll have to be on guard to not lose some of the kind of cross-cultural benefits of the system, right? I mean, we can Zoom all we want, but you and I and Becca sharing a nice glass of orange wine in Tbilisi, that you can't get on Zoom. But I totally agree that we're at a kind of inflection point, perhaps on some of the skills that will be necessary for proper practice of international arbitration. So I've gotten some questions in the chat, which is good. Please send in your questions and I'll do my best to answer them. One question which I think is interesting is a little bit more on the evolution of international arbitration and what you think how it will evolve. If we could kind of pose that question with a regional focus? In other words, what role do you think that regional centers like the Georgian International Arbitration Center and others will play in kind of the future of international arbitration? So it's a kind of question about fragmentation, I guess. But then also, how does it thrive? What role in its best incarnation do regional centers play? How do they thrive? So that's one question. And then another question we have is about tribunal secretaries. And I like how the attendee has phrased it. So is it a good opportunity for up and coming arbitration practitioners, but because it's the parties' arbitration, is that a selfish view? So why don't we, those are the two that we've received. So keep them coming, everyone.
You want me to have a go?
Sure, go have a go.
Regional standards. I believe when I came into this industry, there was one major international arbitration institution, the ICC. It was the market leader, wonderful institution. Of course, it had its issues, but it was there. Today we have many institutions around the world, and frankly, many of them are extremely good. The ICC is still probably the market leader, but you've got so many other institutions with serious caseloads who have earned the respect and the satisfaction of potential users. I think that it's up to the institutions, including in somewhere like Georgia, I don't know enough about Georgia, to be able to persuade people we are neutral, we've got the right kind of arbitrators, we've got the right kind of rules, and we will be recognized. Our awards will be of a high quality and they will be recognized. What is in the rules, that's for each institution to develop. It's very difficult to develop a reputation and it's very easy to lose it. But you look around the major institutions today, you hear very little criticism of them. And the reason is because they've worked extremely hard to make sure there's a good quality. As for the question of tribunal secretaries, let me ask if there's a difference. A young lawyer goes to work for a big law firm, like yours. Yeah? Just arrived in the firm, comes into your group, you've got a new case, you need somebody to help you. In fact, you might have a senior assistant to help you. You might have a junior. That junior is on a learning curve. Whether that junior 10 years later will become a partner, time will tell. Similarly, an arbitrator frequently needs assistance. To have a tribunal secretary, exactly how the tribunal secretary is used, there are different views on that. But that person to have the opportunity of working with a senior lawyer, senior arbitrator, to see how the arbitrator thinks, to see how an arbitrator analyzes, to see how an arbitrator weighs things up. You don't have to follow the arbitrator, but it's just the same as working with a senior lawyer in a law firm.
And do you think that's an expense that the parties should welcome and pay?
That depends on the rules many of the institutions now require the arbitrators to pay for the tribunal secretary, because you also have lawyers who are just who have their own assistants, and that's at the cost of the arbitrator.
That's true.
It depends whether it's for the arbitrator. There is an advantage. If you are paying a large fee to a senior arbitrator, you may be paying a much smaller fee to the tribunal secretary, and you don't really necessarily want the senior arbitrator at that rate running up a bill for doing things that maybe somebody more junior should be doing.
Yeah, absolutely. Similarly, in the arbitrator category, we have a provocative question from another attendee that says, have party-appointed arbitrators had their day? In where institutional arbitration, a panel can be appointed very quickly with a list without the drama of party-appointed arbitrators. Thoughts on that? And then what role, and then there's a couple questions about the role of national mandatory law and contract interpretation, and how that should factor into an arbitrator's approach to a case. Although it's, and then there's a few questions about virtual hearings and whether there are potential procedural objections and challenges to awards. Because, and let me kind of add a gloss to that. You know, we all recognize that the resources of some parties outweigh the resources of others, and you know, one of those resource questions is with regard to their access to internet capability and some of the kind of fancy equipment that you would expect from a major law firm. And is that inequality of arms a due process problem when, you know, it's a lot easier to just get on a plane and all meet in person with pencil and paper, whereas, you know, if you're forced to have fancy cameras and a ring light, is there a due process issue there? So why don't we look at those two? So the virtual hearing setting, is that hurting less well-moneyed parties? How do you handle tricky issues of national law, and have party-appointed arbitrators had their day? These are tough questions, Professor. We pay, that's why you get the big bucks. What do you think?
Well, let's start with party-appointed arbitrators. I hope they haven't had their day. And the reason I say that is that I think that I don't think they're always well used, and that's why they should not have had their day. Parties sometimes want to have an arbitrator on a tribunal. In fact, I think more often than not, in whom they have confidence. Might be a common nationality, might be a common culture. It might be somebody who they feel, it might have somebody who has technical knowledge, who they feel it's lovely to have these lawyers on the tribunal, but maybe with somebody in a case that's got heavy scientific elements, you might want to have somebody on there who's a scientist. So I think that's one issue. And the second issue, as you indicated, in my view, arbitration exists because parties want it. And let's not think that it's the lawyers who want it, because yes, the lawyers put in the clauses, the lawyers advise the clients. If the clients don't want it, there are good national courts to go to. So if you're doing that, let the parties control, because then the next thing is, if you're taking that away, you've got to have the ICC rules. Remember, most of the rule systems actually have relatively permissive rules. You can have one arbitrator or three. You can have expedited proceedings or not. You can have your own procedures in many systems if you agree them. The parties who are making that decision may be in discussion with their clients, or should be in discussion with their clients, and maybe the arbitrators are participating in that discussion as well, once you have the confidence. So then I hope that covers my view on party appointment. I think they have.
Well, let me just, is the view the same on investment arbitration?
Yes. Yes. I also think that it might leave the opportunity. We do have, if there are some difficulties, we do have a diversity problem in helping young people, new people, not necessarily young, they might be older people, new people to get into this industry as an arbitrator. And maybe by parties being able to select somebody who might not have arbitration experience, but might have very, very wide experience in other business areas relevant to the dispute.
Yeah, and we have, I mean, it's difficult in investment arbitration in particular because, you know, states, and I can say this from experience, are not commercially rational, right? I mean, they are political animals first and foremost. And while they're in a commercial dispute, you know, I see in the audience we have at least two lawyers who represent their respective states, and the question always, when I was representing the United States, is, you know, if we lose, can we justify losing with this tribunal? and that's a political decision. So in many ways, you can't take the chance of having a new practitioner sit as arbitrator, even if you're comfortable with their knowledge of public international law and their approach to cases. I think that that's probably a little different from the commercial arbitration case. What do you think?
Well, I think it is slightly different, but you've got that, there's very brilliant young professor. He's only 31 or 32 years of age at the University of wherever. Everybody knows one of the great stars. He's going to get an arbitration and he's going to get his first one. Somebody's going to say, that young professor, he's brilliant. And there's this wonderful lawyer in one of the big law firms, or even a small law firm somewhere around the world. And everybody knows he's an outstanding individual with very good judgment. So he's got no gray hair. Why hold that against him? If that individual, him or her, if that individual's good enough and somebody's got confidence. And then, of course, when they've had two appointments, there was we can use that person as a presiding arbitrator. So everybody's got to start.
So you're saying now that I'm on the ICSID roster, I should start dyeing my hair gray a little bit. That's what yeah. No,
and nor am I suggesting that now you're on the ICSID roster, that you've dyed it black again.
Yeah, fair enough. So here's an interesting one, and mindful of the time. Get your questions in, folks. This is about credibility. So in virtual hearings, are you able, looking at witnesses and making assessments on credibility and understanding fact witnesses and versus expert witnesses and those aspects, are you able to do that virtually in a way that you're comfortable with?
I can't answer that directly. I've had several hearings. I don't think I've had enough experience to say that definitively yes or no. But I haven't come away from the hearings I've had feeling dissatisfied.
Yeah. What
I have found is that I concentrate more. For example, you and I are sitting here talking. I'm looking at you, and I'm seeing you, and that's it.
And we have 70 people in front of us. Yeah.
Okay. Now, if we were in a conference room, or if we were in a lecture hall, it'd be you and I sitting together, and we'd be looking out at however many people were there. Same with the hearing. If you were counsel in front of me, I'd be looking at you and watching your face, and I might be challenging you with a question, but I wouldn't be distracted by the junior lawyer on the one side sending a yellow post-it note to somebody up the side, nor would I get distracted by the fact that somebody walked into the room or walked out of the room. Which you do. You've got two lots of people. The disadvantage is I can't send a post-it note to one of my colleagues to say whatever I want to comment on, whether it's on a witness or a question that I want to put or something. So it has a disadvantage, but I do think the focus I've found extremely good without distractions.
Yeah, and it's interesting. I used to tell junior associates or others when there's a really important moment of the case, like an opening or a closing, that their eyes should be fixed at the speaker, so that if the tribunal looks at them, they'll be redirected just by virtue of where they, the associate, are looking back up to the speaker. I call it Da Vinci eyes, because in Da Vinci painting, everyone always looks at, no matter who it is, baby Jesus or whoever. And I think that kind of, trick or that kind of, feel of a live hearing is lost in these cases. We have more than 70 people that have watched us already, and you and I are the only people that have seen each other. It's going to be an interesting, and the younger lawyers that are forged in the smithy of this kind of virtual hearing setting will, I think, develop tricks and things that we can't even imagine.
Let me go off piste.
Please.
You mentioned at the beginning I was born in South Africa.
Yes, sir.
I had a grandmother here, had aunts and uncles, never saw them. My mother would phone her mother twice a year, it was too expensive. I have a daughter and a son-in-law and a grandchild in Melbourne, Australia. So I see my daughter almost every day and my granddaughter every day on FaceTime. I can't get a hug. That's the only problem. But I can see my daughter every morning, for a few minutes. If I'm busy or she's busy, we have a very quick call. If I've got more time, I maybe spend more time talking to her. So, things will develop, and our processes with the virtual hearings will improve. We're looking at today's technology.
Well, I think that's a wonderful, hopeful and encouraging place to stop our conversation and turn it over to the younger folks to take us forward for next year. But I can't thank you enough, Professor, for your time, your candor, and thank you, of course, to Becca and the Secretariat for inviting us to have this conversation. I think it's just been a total joy from my perspective, and I hope the audience enjoyed it as well. Becca?
Can I just say as well?
I will unhide myself now because it was the interview for 2 persons, and that's why I made hide myself. Really, I will join Patrick's passion, and I will say that it was extremely interesting questions, answers. I'm sure that the participants and the attendees, they enjoyed so much. We tried to answer their questions, what we can, and what Patrick did, and there was other questions, of course. And I think that the 1 hour or hour and a half, it will be definitely not enough for speaking with Professor, of course, with exchanging the views, especially how it will happen in the future. We don't know how it happen in the future, but of course, the new technology, as Professor said, help us in everyday lives. And really, I agree. Thank you very much. From my side, I wanted to ask the questions, but of course, I prefer to give floor to the audience. And Patrick, please, if the final words, Professor.
Well, I'll give Professor Lew the final word, but again, I just to the students and the younger practitioners in the audience, thank you for showing up. It's so important to stay connected as an arbitration community in these times, and my door is always open to young practitioners who have questions about career and things like that. And I'm a great supporter of folks in Georgia. I think that it's essential that secretariats that are doing great work, like the Georgia International Arbitration Center, and are kind of supported. And it's just a privilege to speak before you. And most importantly, it's a privilege to have heard from Professor Lew. So I'll give Professor Lew the final word.
Well, finally, I'd like to first of all thank the Georgia Center for inviting me. Been a pleasure to come. I hope one day I'll have the opportunity to actually come to Georgia in person, to meet you all in person, and perhaps even to attend one of your conferences when conferences come back into fashion and we're allowed to travel. I hope those who've been listening have found something of interest. These are all very interesting questions, and what's challenging about arbitration, they're not static questions, because what we see as a problem today will resolve itself or might be changed in years to come. And that's because we don't come from one place. We come from a whole series of different countries, different legal systems, different cultures, different mentalities. So always keep that in mind as we battle our way through. And then finally, Patrick, we had met previously, and that was a pleasure, and it's a pleasure to have worked with you today. And I hope we'll get an opportunity when this pandemic is over to meet up again.
So well, thank you, and Adloba to everyone. Thank you very much.
Thank you. And maybe finally, I will add that it was really privileged to have you and Professor, of course, and you have mentioned that I know that not many, but there are the attendees who has been former your students, and they are really, it is a good opportunity to have you and to listen your views, remarks and feedbacks. And also, Patrick, let me thank to all the participants for the questions. It was really interesting because without them, this event will never happen. And with this, maybe I will say goodbye. Again, thank you, Professor. And I wish you, and I wish myself also, and all the local practitioners and from the region, that we will find out one day having conversation in person in Tbilisi with Georgian wine and hospitality. Thank you again, Patrick. Thank you very much, Professor.
Madloba. Bye.
Bye-bye to you.
Bye.